My husband smiled when his lawyer asked the judge to read my father's will. That was the detail nobody forgot. Not the bailiff by the door, hands behind his back, watching the room with the patient disinterest of a man who had seen 1,000 hearings and expected nothing new from this one. Not the court reporter, whose fingers had been moving for nearly an hour, without once looking down at her own hands. Not Brent Halpern, my husband's attorney, a polished, expensive man in a charcoal suit who had spent 10 months turning my divorce into a controlled extraction. And not Grant Mercer himself, seated at the petitioner's table with his shoulders square and his hands resting on a leather folder he had not once opened, who had walked into that courtroom believing that everything worth taking had already been taken. The townhouse, the company, the accounts, the cars, the art we had bought together at an auction in Philadelphia, where Grant had bid aggressively on 3 pieces, and then told me at dinner afterward that art was about confidence, not taste. The furniture, even the smaller things, the espresso machine, the wine fridge, the Japanese kitchen knives neither of us had ever used properly. All of it had been itemized and allocated and moved, piece by piece, onto a side of a legal spreadsheet that Brent Halpern had maintained with the loving attention most people reserve for living things. By then, Grant had every reason to feel confident. He had temporary possession of the townhouse on Wexler Square. He had operating control of Mercer Urban Holdings, the development company he had built and leveraged and mortgaged and described in every filing as the central asset of the marriage. He had frozen the joint accounts, redirected the narrative, and persuaded the court, at least provisionally, that I was a quiet daughter of a wealthy dead man, and therefore in no meaningful danger. That had been his strategy from the beginning. Take everything in the present, point at my future, call it fairness. So when Brent Halpern stood and told the court that support in final distribution could not be decided properly without reviewing the terms of my father's estate, Grant leaned back in his chair and smiled. Not nervously, not hopefully, not like a man taking a risk he wasn't sure about. He smiled like a man who believed the last sealed document in the room had just become his. I remember looking across the courtroom at that exact moment, past the clerk, past the court reporter, past the empty gallery seats, and seeing his face clearly, seeing the satisfaction in it, seeing the way he held his jaw, slightly lifted, the posture of a man who had rehearsed a victory so many times that the actual moment felt like confirmation rather than surprise. And I remember thinking something very simple. You should never look that please before a paper you have never read. The clerk carried the probate packet to the bench. Judge Celia Morrow, 22 years on the family court bench, broke the seal with a letter opener she kept beside her water glass. She removed the will first, then the codicil, then 3 attached schedules held together by a black clip. Grant's expression held for the first few seconds. Confidence has a delay built into it. It survives briefly, even after the facts have already turned. Then the judge began to read, and the room changed. To understand why Grant Mercer thought my father's would finish me, you need to understand what he thought he knew about me. He thought I was the soft one. Every family with power has one, the child who did not fight for position, the one who stepped sideways while the others stepped forward, the one whose name appears on the gentler pages of the family story while the harder pages belong to someone else. Grant believed I was that child. My father, Benedict Rowan, had built Rowan Freight and Marine over 40 years into a private logistics empire that touched 3 ports, 2 rail corridors, and more private holding entities than most people would ever have reason to create unless they intended to survive both regulation and family. My brother Oliver inherited my father's appetite for visible authority, the kind that spoke first in meetings and mistook volume for clarity. My sister Adrian inherited his precision. She was quieter, more surgical, the kind of person who played chess several moves ahead and never announced the ones that mattered until they had already landed. And I, according to Grant, had inherited neither quality. I ran the housing restitution arm of the Rowan Foundation. I spent my days in title disputes, neighborhood settlements, redevelopment mediations, and compensation hearings, where people with less power than the people across from them tried to explain what had been taken and how politely it had been taken. Grant looked at that life and saw softness. What he failed to understand, what men like Grant almost always fail to understand, is that softness and patience are not the same thing. If you spend enough years in rooms where power is lying in a calm voice, you stop being impressed by polish. You learn to hear pressure inside courtesy. You learn what entitlement sounds like when it is learned to smile. And most importantly, you learn to wait. Grant never understood waiting. He met me at a preservation dinner in Baltimore, one of those polished civic evenings where everyone says the word community while discreetly measuring who controls which blocks of it. By then, he had already spent over a year trying to position Mercer Urban Holdings near a cluster of riverfront parcels still tied up in old Rowan entities and environmental restrictions he could not navigate alone. He needed proximity, not ownership, not yet, but access to the rooms where decisions about land and trust and timing were made by people who had known each other for decades and did not invite outsiders easily. Marriage creates that kind of access. He courted me with discipline. He was not clumsy. He was not loud. He learned what I actually liked instead of performing what he assumed wealthy women wanted. He remembered names, details, stories I had mentioned weeks earlier. He listened in a particular way, practiced. Men listen when they want to be mistaken for sincere ones. He let Oliver dislike him. He let Adrian distrust him. He treated both reactions as manageable weather. What he did not know was that my father had seen him with complete clarity within the first half hour. 6 weeks before the wedding, my father called me to his office on the 31st floor of Rowan House. It was a room I had known all my life. Dark wood, gray harbor light, framed shipping maps on the walls. A desk broad enough to make most visitors cautious before they reached the chair across from it. My father sat behind it with the particular stillness of a man who had already decided what he wanted to say and was now deciding how much of it to release. "You've read the agreement," he said. He meant the prenup. "Yes." "Every page." "Yes." "And you're still marrying him." "Yes." He stood and walked to the window. Outside, a tug was pulling a barge slowly across the harbor. "Adrian thinks he wants access," he said. "She's probably right." He nodded once, then turned and opened a drawer in his desk. He rested 2 fingers on a cream envelope inside. "A good will does 2 things, Claire," he said. "It transfers property, and it identifies appetite." I looked at the envelope, then back at him. "If Grant Mercer ever dragged you into court over what he thinks I left you, do not stop him." "What's in that?" "Not for today." "That's not an answer. It's the only one you're getting." He closed the drawer. "If he is exactly who your sister thinks he is, speed will help him more than it helps you. Let him move first. Let him describe the world. Let him count what he thinks is yours. Then let the paper correct him. You think he'll file?" My father turned from the window and looked at me directly. "No," he said. "I think men who confuse access with ownership always do." I left his office with no explanation, no copy of whatever was in that envelope, and no illusion that the conversation had been casual. I married Grant anyway. For the first year, he was careful, measured, publicly affectionate. He came to Foundation events. He called my father sir. He learned how Adrian operated in meetings and studied Oliver's habits closely enough to know when to engage and when to stay quiet. Then he began reaching. He asked about the river parcels, about trust-based restrictions, about which Rowan entities still use private paper instead of conventional lending. 8 months later, my father was diagnosed with pancreatic cancer. He remained himself almost all the way through it. He still reviewed paper, still took calls, still corrected numbers from memory. The authority stayed long after the body began to fail. 2 weeks before he died, he called me back to his office and handed me a sealed envelope with my name written on the front in his exact, narrow script. "Open this only if Grant files first," he said. "And if I file, then you won't need it." "What did you do?" He raised one hand. "Listen carefully. Men who build their lives on leverage eventually begin to believe every relationship is a credit facility. If he files, do not answer with speed. Let him overstate. Let him turn assumption into pleading. Then let the court read what I wrote." He coughed once, steadied himself, and added, "And Claire, do not let Oliver freelance." That nearly made me smile. My father died on a Monday in October. Grant filed for divorce 38 days later. Friday afternoon, through Brent Halpern, the filing was aggressive in a way only expensive people can make aggression look administrative. He sought exclusive temporary possession of Wexler Square. He sought control of the joint operating accounts. He sought continued management authority over Mercer Urban Holdings. And then he argued that any meaningful support award to me would be unfair, because I was about to receive, in Brent's words, substantial separate wealth through imminent testamentary transfer. That sentence did most of the work. He did not just want the marriage dissolved. He wanted the court to see me as a woman too rich to require protection. Temporary orders move faster than truth. By the end of the first month, Grant had possession of Wexler Square, control of the company, and the kind of early momentum that makes men like him confuse procedure with victory. Oliver wanted war immediately. He came into Adrienne's office the afternoon the temporary orders were entered. "He took the house," Oliver said. "He took possession of a house," Adrienne corrected without looking up. "He froze the accounts. He froze joint accounts. He's telling the court she doesn't need support because Dad died." At that, Adrienne did look up. "That," she said quietly, "may be the most expensive sentence he has written so far. I hired outside counsel. I wanted clean lines. No family firm. No lawyer who could be framed as an extension of Rowan institutional power. I hired Leah Warren. She was calm, precise, and allergic to spectacle. Grant mistook her restraint for weakness. That mistake cost him everything. 3 months into the case, Adrienne called me to her office on a Sunday. 6 months before my father died, Rowan Capital had quietly acquired the outside loan sitting above Mercer Urban Holdings' most important development facility. The original lender in Connecticut had sold the paper. Rowan Capital had bought it. Grant had signed a consent package during one of his liquidity scrambles without apparently understanding who had ended up on the other side of the transaction. That alone was significant, but what made it devastating was the architecture around it. The direct loans from my father and his entities contained acceleration language. If my father died, or if Grant filed for divorce against me, the full balance became immediately due. Those defaults triggered the outside loan. That loan was secured by Grant's membership interests in Mercer Urban Holdings. In plain terms, the company Grant was fighting hardest to keep had become collateral for debts he had just activated himself. He bought the lender, I said when Adrienne showed me the file. He bought the paper, she corrected, which is more useful. Did Dad intend this specifically? Adrienne considered the question for a moment. Dad did not spend 40 years leaving strategic outcomes to accident. That night, I opened the envelope. Inside was a single page in my father's handwriting. "Do not mistake silence for surrender. If he asks the court to read my will, let him. He will think he is measuring what is yours. He will actually be confirming what is his." At the bottom of the page, one final line. "A man who counts on your future before accounting for his present should be answered with paper." By the 9th month, Brent's proposed distribution schedule was a polished act of legal theft disguised as efficiency. Wexler Square to Grant. Mercer Urban Holdings to Grant. Vehicles to Grant. Most of the joint accounts to Grant. Support minimized because I would soon inherit substantial wealth. Then Grant made the move my father had been waiting for. At the pretrial conference, Brent argued directly that the court could not fairly decide the case without reviewing my father's will and the nature of my expected inheritance. Judge Morrow ordered the probate packet produced under seal. Grant walked out of that hearing believing he had forced open the last useful document. He had. He just had no idea who it was useful to. On the morning of the hearing, Grant wore confidence like tailored wool. Brent arranged his exhibits with the careful finality of a man already composing his invoice. Leah sat beside me with 3 tabs prepared and a legal pad she barely touched. Brent stood first. He was smooth. He was always smooth. He argued that Grant had maintained a standard of living, operated the principal business, and should retain control of the economic engine of the marriage. He reiterated that any substantial support award to me would be unfair because I stood on the threshold of a large inheritance. He used the phrase, substantial inherited liquidity. Judge Morrow's expression shifted slightly, the way judges' expressions shift when they hear language they already expect to dislike. Leah stood next. She did not argue loudly. She said only that expected inheritance is not present access, that Brent's theory relied on assumptions about instruments the court had not yet reviewed, and that if the court intended to rely on a will, it should rely on a complete document. Then she sat down. Judge Morrow opened the probate packet. She read silently for a long time. Then she looked up. All right, first things first. The courtroom went still. There is no immediate inheritance. Brent's pen stopped moving. The trust created for Mrs. Mercer is fully discretionary. There is no mandatory distribution schedule, no present right to principal, and no basis for treating those assets as currently available for support or allocation purposes. Grant's smile weakened slightly, but he still had the posture of a man waiting for the next paragraph to fix the first one. It didn't. Judge Morrow turned a page. There is, however, something else. That was the moment Grant sat forward in his chair. The judge continued. The estate holds enforceable promissory notes assigned by Mr. Mercer and by Mercer Urban Holdings. The total amount reflected in the schedules before me exceeds $6 million. Grant turned to Brent. It was a quick movement, instinctive, the kind of turn a man makes when he needs his lawyer to say something reassuring immediately. Brent did not say anything. He opened his file, flipped one page, then another. Whatever he was looking for was not there. Judge Morrow kept reading. Those obligations became immediately due upon either the death of the lender or the filing of a divorce action by Mr. Mercer against Mrs. Mercer. Grant's hand went flat against the table. His jaw tightened. He looked back at the bench with the fixed stare of a man who had just heard something mechanical snap inside a structure he thought was solid. For the first time in 11 months, I was not waiting for the next thing Grant would take. I was watching the court count what he owed. Judge Morrow turned another page. There is more. The room seemed to contract around that sentence. The estate, through Rowan Capital Partners, also holds a senior secured loan against Mercer Urban Holdings. That facility is cross-linked to the obligations I just described. When those notes accelerated, the company debt was triggered as well. Now Brent stopped performing composure. He leaned toward Grant and whispered something. Grant did not respond. He was staring at the bench like a man watching the floor open beneath a building he had just finished furnishing. Judge Morrow's voice remained perfectly level. In plain terms, the business petitioner has fought hardest to preserve his collateral for debts he activated by filing this action and then failed to disclose. She lifted the next page. And one more thing. The room braced itself. Wexler Square was never marital property. That landed harder than anything before it. Title remains with Rowan Residential, LLC. Occupancy was permitted under a revocable family license. That license terminated automatically the day Mr. Mercer filed for divorce. Oliver, seated in the second row under explicit instruction to remain invisible, shut his eyes for one full second in what I later understood was the closest thing to laughter he could physically contain. Grant looked at Brent again, but longer this time, not with anger, not yet, with something worse. Recognition. The recognition of a man who was realizing that his own lawyer may have been as surprised as he was. Judge Morrow set the will down on her desk. The sound of paper touching which should not have been audible from where I sat. It was, "Mr. Mercer," she said, "were you aware these obligations existed?" Grant swallowed once. "They were family accommodations," he said. "There was never any indication." "That is not what I asked." Silence. "Yes," he said finally. "I knew there were loans." "Did you disclose them in your mandatory financial statement?" "No." "Did you tell this court that Wexler Square was marital property?" "Yes." "Did you know title was held by Rowan Residential LLC?" A pause, long enough that every person in the room understood the answer before he gave it. "Yes." Judge Morrow nodded once, not with sympathy, with conclusion. "Then this court has been making temporary orders based on materially incomplete financial disclosures." That was the sentence that changed everything. Not the debt, not the loans, not the house. That sentence. Because it meant the court had been manipulated. And family court judges, in my experience, can forgive many things. Being manipulated is not one of them. Brent stood, trying to recover. "Your Honor, with respect, there are nuances in privately held family structures." "There are always nuances," Judge Morrow said. "There are not always $6 million in undisclosed debt secured against the very asset a party asked this court to protect." Leah stood. She did not raise her voice. She did not gesture. She did not look at Grant. She said 5 words. No further argument, "Your Honor." Then she said 2 more. "Respondent rests." Quiet. Clean. Final. I did not smile. My father had taught me never to celebrate before the paperwork was finished. Judge Morrow vacated Grant's claim to continue possession of Wexler Square. She ordered amended sworn disclosures within 10 days. She barred any further argument that my inheritance should reduce support. She awarded interim attorney's fees to me based on bad faith conduct. She set a separate sanctions hearing to address the omitted debt, the false characterization of assets, and the misleading financial presentation. Grant did not speak again. He sat at the table, one hand still flat against the surface, as if holding on to the last stable thing left in the room. Outside the courtroom, Oliver found us first. He had managed, against his nature, to stay quiet during the entire hearing. The effort appeared to have physically taxed him. "Our father," he said to no one in particular, "was a deeply unreasonable man." Adrian, who had trusted paper from the beginning and emotion not at all, looked at him. "You say that like it's criticism." Leah was speaking with the clerk about amended filings. I stood by the windows at the end of the corridor and looked down at the city while the air slowly returned to my lungs. Adrian came to stand beside me. "You knew enough to stay still," she said. "I knew enough to wait." She nodded once. "He signed a consent package himself," she said. "I checked again last night. He had the assignment notice. He just never thought it mattered. He thought the money would always behave like gratitude." "Yes," Adrian said. "That was as large a mistake." Oliver joined us a moment later. "Did Dad hate him that much?" he asked. Adrian folded her arms. "No," she said. "He understood him that well." The sanctions order came 2 weeks later. Judge Morrow did not grandstand. She did something worse. She described Grant accurately. She found that he had pursued temporary control and final allocation to materially incomplete disclosures, unsupported reliance on speculative inheritance, and false characterization of both ownership and debt. In family court, there are many ways to lose. One of the worst is having a judge use calm language to explain exactly who you are. The final divorce order came 6 weeks after the will was read. It did not restore every dollar. Courts rarely do. By then, too much money had already been burned by litigation, delay, and ego. But the shape of the ending changed completely. Wexler Square left a marital balance sheet entirely. My trust remained beyond Grant's reach, untouched and useless to his argument. Support was recalculated without fantasy. Attorneys' fees were awarded substantially against him, and Mercer Urban Holdings, the company he had fought hardest to keep, remained tied to debt that now had a name, a schedule, and a legal record. Rowan Capital enforced its rights. Investors started asking sharper questions. Lenders became less patient. Projects stalled. Restructuring began. Grant lost control in stages, which was harsher than losing it all at once, because each stage required him to sit in a room and negotiate away something he had once believed was permanently his. First, the Philadelphia project went, then the Wilmington parcel. Then the membership interests that had once formed the core of his financial identity stopped functioning like assets and started functioning like a cautionary tale. He sold what he could. He refinanced what he couldn't. He moved offices. Then he moved cities. Men like Grant rarely disappear dramatically. They reduce. They become smaller in a different zip code where their name means less, and their story has not yet followed them. The last time I saw Grant Mercer, he was carrying a cardboard file box out of an office that had once displayed his name in polished steel letters above the reception desk. He looked at me once across the parking lot, as if searching for one final argument, one last angle, one more version of events that might still land in his favor. Then he got into a rental car and drove away. There was one final conversation that mattered. It happened in my father's office after probate closed and the trustees had finished the last of the administrative work. The room felt larger without him, less certain, somehow, as if part of its structure had always been psychological, held together not by walnut and glass, but by the particular gravity of the man who had sat behind that desk for 40 years. The will lay open on the surface, not the myth of it, not the courtroom performance of it. The actual document, measured clauses, tight definitions, merciless clarity. Oliver stood by the bookshelves. Adrian sat in one of the leather chairs. I stood by the windows with my father's note in my hand. Oliver broke the silence. I spent most of my life assuming Dad trusted me most with the hard decisions, he said. Adrian did not look up. You spent most of your life assuming a great many things. To his credit, he let that pass. Then he looked at me. He trusted you with time, he said, which, in retrospect, is worse. I unfolded the note again. Do not mistake silence for surrender. For years I believed my father's greatest gift would be what he left me. I was wrong. His greatest gift was teaching me that patience is not the absence of action. It is choosing the right moment, so the truth can no longer be argued. I looked around the office, at the maps, at the harbor, at the ledgers and directories, and the life of a man who understood that power is often just preparation disciplined enough to become invisible. He wasn't trying to save the money, I said quietly. Adrian looked up. No, she said. He was making sure you were never the doorway to it. That was the truth of the whole thing. Grant thought my value was what would eventually pass into my hands. My father understood that my value was what could not be forced, hurried, attached, or converted by marriage into access. The will was not just a transfer of wealth. It was a protection so complete that the man who tried to exploit it ended up proving, in front of judge and under oath, that he had no claim to anything in it. My father never won my divorce. He simply refused to let someone else write its ending. Some fathers leave their daughters an inheritance. Mine left me a document that made sure no one would ever confuse loving me with owning me. If this story stayed with you, if you've ever known someone who was underestimated because they chose stillness over noise, remember this. The most dangerous person in any room is usually the one who has already been counted out. Stay with me for the next story, because the next one I'm going to tell you is about a woman who was left with nothing after her husband's death, until his lawyer opened a second envelope no one knew existed. You won't want to miss what she found inside.